if they find that he is guilty of the acts of physical abuse, on the grounds that his marital fault disqualifies him from being the recipient of alimony. You need to be alert as to whether or not your home jurisdiction follows a rule that includes marital fault as a factor or eliminates marital fault as a factor. Once we have determined the amount of alimony, it remains also to determine the duration of the alimony award. That is also strictly within the discretion of the court. The court can order alimony to be paid as a single lump sum payment. The alimony can be fixed as, in effect, a stipend, a settlement, an endowment of sorts, and that's usually called alimony in gross. The duration of that award is obviously, once it's paid, the obligation is over. More commonly, I think, alimony will be in the form of periodic payments, the duration of which will set by the court. The court will sometimes adopt a set period, such as 5 years or 3 years, or a period linked to a particular event. $1,500 a month until the wife finishes her medical degree. But sometimes the order will be for an indefinite period, and that is entirely appropriate. There are some automatic termination issues that come up with respect to these alimony awards, and we should be aware of those as well. Alimony will terminate automatically upon the death of either the payor or the recipient. In most states, alimony will also terminate automatically upon the remarriage of the recipient. An issue that has proved somewhat more controversial is whether or not alimony will terminate if the recipient cohabits with someone without marrying that person. There is no clear consensus on this. Some states treat the cohabitation as the equivalent of a remarriage, and therefore as an occasion for termination of alimony, but other states do not. In many states, the cohabitation will be looked at on the merits to see whether or not it has affected the economic circumstances of the recipient spouse. If the recipient spouse is cohabiting with someone who is financially well-to-do, and if that individual is providing a modicum of support, then that may be an occasion for terminating the alimony by the ex-spouse. The one thing to understand is that in virtually every jurisdiction, occasional intercourse, a social relationship with someone that includes physical intimacy, that in and of itself does not terminate the alimony award. It would only be cohabitation. Well, if that's the duration of the alimony award, the question is then, can the alimony award ever be changed? What about modification of alimony? Well, the first thing I should say is that if alimony is being paid out pursuant to a separation agreement, most jurisdictions will enforce the separation agreement as written and not allow the parties to seek modification. The parties will be held to their bargain. There are some states that follow the view that if the separation agreement is, quote, merged into the divorce decree, then in effect the contract has been abrogated and substituted for it is a court decree which is modifiable. But absent the existence of a procedure for merger of a separation agreement into a decree, and absent a specific order that agreement has been merged into the decree, there will be no possibility of modifying that separation agreement. On the other hand, when alimony is being paid out pursuant to court order, modification may be a possibility. A lump sum award, alimony in gross, is not going to be modifiable because it's a single episode, a single event, and once it's done, it's done. But in the case of periodic payments, either party may apply for modification upon a showing of a substantial change in circumstances. Basically, that substantial change in circumstances can relate to any of the factors that helped us arrive at the original alimony award in the first place. For instance, resources of the payor. Maybe the payor has been fired or laid off. The age health, and physical and emotional condition of the recipient. Maybe the recipient has contracted an illness and can no longer work. Maybe the recipient has received a lottery windfall and is now in a position where she or he has ample resources. All of these sorts of things, the completion of schooling, all of these things would be change in circumstances warranting a modification of the award. If modification is deemed appropriate by the judge, however, modification will operate prospectively only. That's important. It will operate prospectively only. Only affects future payments. What that means is that if there are any arrearages, any past due payments, you cannot get them modified. Those are liquidated debts that you owe your ex-spouse, and you have to pay them, and no modification is going to be available. Let us assume, having raised the issue of arrearages, that we have a spouse who simply doesn't pay alimony. What are the mechanisms available for the recipient spouse to enforce the alimony award? Well, basically, the failure to pay alimony under a court order is contempt of court, and the court has all the powers that you would expect to attempt to enforce its decree. It can seize assets, order them sold, and have the proceeds delivered to the recipient. It can garnish wages, and indeed it can even have you arrested and incarcerated for your contempt of court in failing to pay that alimony award. So that's the structure of alimony as we see it today. Let us shift our focus to property division and see how that operates in the contemporary climate. There are two approaches to property division in the United States today. The predominant approach is an approach called equitable distribution. The minority view, prevalent mostly in Western states, is community property. While there are some very significant differences in the schemes, they have moved closer and closer together over the years, and at least for present purposes, as we shall see, the differences are not particularly enormous. Let's talk about property division under the equitable distribution system first. In an equitable distribution state, the first task of the court in making property division is to separate all of the items owned by the parties into three categories: his, hers, and theirs. The his and hers pile will be referred to as separate property. The theirs pile will be referred to as marital property. The court engages in that separation because the general rule is that each party gets to retain his or her separate property, and that only the marital property is subject to distribution by the court. Now, having said that, let me note a minority position. Some states, Massachusetts, I believe, is an example of this approach, some states do not distinguish between marital and separate property. These states will take every stick of asset owned by either spouse and treat it as subject to distribution. In those states, there is effectively no distinction between marital and separate property. But most states, your first task is to divide the property up as I have suggested. What constitutes separate property? Well, first, property acquired by a spouse prior to the marriage is considered to be separate property. Anything you own prior to the marriage. John, before getting married, has labored very hard, saved a lot of money, and bought a piece of real estate in the form of a cabin on a lake. That cabin on the lake is his separate property. In some states, anything acquired in exchange for property owned prior to the marriage will also be considered separate property. In other words, there will be a tracing of assets. If John, having owned that cabin on the lake that he bought with his savings prior to the marriage, sells the cabin and takes the proceeds and invests it in a mutual fund, the mutual fund would then be considered a separate property. In other states, there will not be a tracing of assets. It's simply one of those areas where there is a diversity of opinion. Second kind of separate property. Property acquired after either the filing of the divorce complaint or the date that the parties formally separated from each other. Although the parties at that point are still married, their economic interdependence is obviously at an end. Things are on the rocks, and so property acquired after that point will be treated as separate property. So property before the marriage, property after the marriage, both separate property. When I say after the marriage, I mean after the filing of the complaint. Third kind of separate property. Legacies or gifts received by individual spouses in their own individual names. Separate property. Aunt Matilda leaves her beautiful diamond necklace in her will to the wife, and only to the wife. That is separate property of the wife. Husband is given a gift by a friend in the form of a very expensive Rolex watch. That watch is his separate property. Fourth kind of separate property. Assets that the parties have agreed to designate as separate property pursuant to an agreement. That agreement might be an antenuptial agreement. That agreement might be a contract that they enter into during the course of the marriage. And fifth, although there is some disagreement about this, many states treat personal injury compensation as separate property. Personal injury compensation. A tort award for your own personal injuries. So there are 5 kinds of separate property that we've identified. Let me, before leaving the subject, add one further element to that description. Many kinds of separate property will augment their value as time passes. They will appreciate in value. John owns that cabin on the lake. Maybe he bought it for $40,000. But over the course of a 10 or 15 year marriage, that property might appreciate to $100,000. What is the treatment of the augmentation or appreciation in value? Is that also separate property, or is the appreciation attributable to the time of the marriage going to be treated as a marital asset? The answer is that the states differ. Some states will treat the appreciation in value as separate property, whereas others treat it as a marital asset. Hard to generalize in domestic relations law, and so consequently, I once again remit you to a review of your own local materials to be certain you have that point correct. Once you have identified the separate property, everything else is marital property. Everything else is marital property. In effect, we label as marital property everything earned by either party during the course of marriage. Everything acquired by them during the course of marriage. This is true regardless of the form in which title may be held. This is true even if only one spouse works and the other spouse remains at home. This is true even if the wealth in question is not the product of effort but is rather the product of luck. So it would be true for gambling winnings or lottery winnings. It includes not only tangible assets but intangible assets, including such things as interest in insurance policies, future interest in real estate, stock options, and rights in pension plans. Let me say a few extra words about pension plans because they have been the subject of an incredible amount of domestic relations litigation, and your instructor may be eager to explore your command of the field. Pension rights are, first of all, notoriously difficult to value. They are notoriously difficult to value because, first of all, in some instances, they may not even be vested at the time of divorce or annulment. Many companies do not guarantee the receipt of any pension money unless you spend a certain number of years with the company or pay in a certain amount of money to the pension fund. Second of all, the ultimate value of the pension is a function of how long you remain with the employer and how much you continue to contribute. How do courts divide pensions if they're going to treat them as marital assets? Well, there's basically 2 approaches that they can use. One approach is to take expert testimony and, despite all the difficulties, assign a present value to the pension. Just try to figure out how much it's worth. And then attribute that asset as having been given to the employee who is going to receive the pension eventually, and divide the other assets accordingly. Let me see if I can't make that a little more coherent with an example. Let us say that the husband works for a company that has a pension plan. Let us say that after appropriate expert testimony, the court concludes that the present value of the pension is $100,000. Let us assume that the couple has $400,000 in other marital assets. Let us further assume that the court decides that an equitable distribution would be an even 50-50 split. What the court will do is it will take the $400,000 of other assets and give $250,000 to the wife. That represents half of the $500,000 aggregate. The husband would get $150,000 of assets and be left to keep his pension, which has a present value of an additional $100,000. That's one methodology the court could use. Alternatively, the court could simply retain jurisdiction. Retain jurisdiction until such time as the husband eventually retires. If at that point the husband does begin receiving pension benefits, the court can then issue orders at that time splitting up the pension proceeds as they come in on a monthly or yearly basis. This is sometimes called a reserved jurisdiction approach. And when the court does that, typically it will actually address its order to the pension plan administrator, not to the husband, to make sure that the money will not be diverted as it comes due. Federal law requires pension administrators to honor state domestic relations orders, provided those orders meet certain prerequisites. An order that meets the prerequisite is usually referred to as a qualified domestic relations order, or a QRDO. And if the order is a QRDO, the pension plan administrator must honor it. The rule concerning pensions, the discussion that I just engaged in, applies to military pensions as well as to civilian pensions. But there is one limitation on this. It is apparently the case, under present law, that Social Security benefits will not be subject to division as property. They are not treated like other pension assets. There's one other type of possible marital property that can pose difficulties and that we need to spend a moment on, and that is the problem of professional licenses and graduate degrees. Some states treat such items as divisible assets. They will, in effect, calculate the present value and use the same approach as I described with respect to pensions under the present value approach. New York is one of the states that follows this approach. In a case called O'Brien, they did exactly this with respect to the value of a medical license. Having earned it during the course of the marriage, it was treated as a marital asset, and that was then subject to valuation and became a factor in distribution. Some states even go one step further, and they hold that the value of a celebrity status can be subject to division and can be treated as a marital asset. This has happened, among other places, in New Jersey, in a case called Piscopo versus Piscopo. A case that I think probably illustrates the dangers of attempting to value someone's celebrity. If you cast your mind back to the brief fleeting celebrity of the litigant in that case, you will appreciate the difficulty the court must have confronted. Now, having said that, the majority of states do not treat a degree or a professional license as an asset subject to distribution. Rather, the courts in those jurisdictions reach effectively the same result by treating the relative contributions that were made by one spouse to the education of the other and the relative earning capacity of the degree-holding spouse as factors bearing on the propriety and amount of the alimony award. So I don't have to treat your medical degree as a divisible asset. I can take your medical degree and use it to reason that you're going to make a lot of money and therefore you can afford to pay a lot of alimony to your ex-spouse. There is a third approach to professional degrees. You can treat it as an asset. You can use it as a factor bearing on alimony and not treat it as an asset, but there's an intermediate approach. Intermediate approach is an approach called reimbursement. In effect, what the court will do is it will look at the actual out-of-pocket expenditures of the spouse who does not hold the degree made to support the degree holder during the course of his or her education. And then, as part of the property order reimbursement of that money spent on tuition, spent on housing, spent on food, and even perhaps an order that will include compensation for the lost family income suffered while one of the spouses went to school. That reimbursement, in effect, is designed to compensate the non-degree holding spouse for the sacrifices that were made during the period that the other spouse was in school. California has adopted that approach explicitly by statute. Other states follow it by case law. So that gives you some sense, I hope, of how property will be divided between separate property and marital property. Having piled up the assets into the two columns, the court's next task is to make a distribution of those assets that we label marital. How does the court do that? Well, it does it, you'll pardon the expression, equitably. That's why we call it equitable distribution. What does equitable distribution mean? Well, it means that the court will look at a variety of factors and then follow its own best instincts. What are some of the factors? Some of the factors are the duration of the marriage, the age, health, and occupation of the parties, the income levels and employabilities of the parties, the liabilities that the parties are going to be responsible for paying off. Does one of them owe debt in a particular category? Question of whether one of them is a custodian of minor children. The degree to which each of them contributed to the augmentation of the family wealth, including the degree to which there were contributions made as a homemaker. And indeed, any other factor that seems rationally related to coming up with an equitable distribution of the property. The majority of states do not consider marital fault in the distribution of property, although there are some that will allow it to be considered. And property division, once arrived at and ordered by the court, is not modifiable. Once it's done, and it's final. That's the system that we confront under equitable distribution. What about the situation for community property states? Well, community property, as I intimated earlier, is a fairly complex subject. Indeed, in many law schools, it is offered as an entirely separate advanced course in property and domestic relations. For present purposes, the chief distinction is that community property states will take the marital assets and divide them equally rather than focus on a list of equitable factors. In effect, it's just going to be split down the middle. Everything that comes into the marriage and is a marital asset or a community asset will be split evenly. There is actually a trend in some community property states to split the community assets equitably. Where that exists, obviously, community property begins to look an awful lot like equitable distribution. Let me conclude this discussion of economic issues with a brief reference to certain tax consequences of divorce economics. Alimony first. The rule here is very simple. Alimony payments are deductible by the payor and treated as taxable income in the hands of the recipient. Property transfers are the other way. The transfer of property pursuant to a property division order is a non-taxable event. So if the court says, as part of a property transfer or property distribution order, if the court says to the husband, sign over your IBM stock to your wife, she gets that as part of the equitable distribution of the property. That signing over of the stock, while normally would be a transfer and therefore might trigger a tax liability, non-taxable event. That means that the recipient of the property has a carryover basis in that property. The carryover basis means that when the recipient ultimately sells the asset, the gain will be calculated based on what the other spouse paid for it long ago. There's no step up or increase in the basis, but rather carryover basis. Well, those are the economic issues that attend marital dissolution, and it takes us to the threshold of our fifth and final topic concerning children. Before tackling that one, it seems to me once again a suitable moment to take a brief break and to resume in just a moment with our discussion of children. Last of our 5 major topics in this discussion of family law, and that is the topic of children. While we are going to cover a large number of subsidiary topics in this discussion, I suppose I can give you a somewhat flip summary of the entire field of children in a very brief 3-slogan summary. This is, in a sense, a roadmap of where we're going to go. The basic rules concerning children are, if you don't want to have them, you don't have to. If you do want to have them, you can. But if you have them, you got to take care of them. That basically summarizes the current approach to families and children. Let's talk about that first proposition. If you don't want to have them, you don't have to have them. Namely, family planning. This is, in some family law courses, a fairly important topic, but other teachers choose to spend little, if any, time on it. Let me simply remind you of things that I suspect you know and remember from constitutional law and from reading the newspapers. Contraception is available in the United States, and there is a constitutional right to obtain it. It can be regulated like other drugs and medical devices, but you cannot forbid access. Persons of any age and any sex may have access to them. I suspect you're all familiar with Griswold versus Connecticut and its articulation of a privacy right in that regard. Another way that people may choose to avoid having children is through the termination of pregnancies. In the current state of the law, abortion is also constitutionally protected. However, states may regulate abortion in ways that do not unduly burden the right. I will leave to other areas of the law school curriculum or to your own investigation the nuances of the undue burden test. Suffice it to say that while some regulation is permissible, the absolute bottom line availability of the constitutional right to abortion remains. So, if you don't want to have children, you don't have to have them. But assume that you do want to have them. Well, what does the law have to say about that? Well, what the law has to say about that is that you have a constitutional right to procreate and a constitutional right to have children. More interesting problems recently have been posed not by that bedrock constitutional right to biologically reproduce, but rather have been posed by novel reproductive technologies. And I just want to say a brief word about these novel reproductive technologies, and particularly about some of the legal consequences that flow from their utilization. One novel reproductive technology, which has been around for a while and is perhaps no longer deserving of the label novel, is artificial insemination. Artificial insemination is permissible. It is a perfectly legitimate way to have children. The question that comes up in many artificial insemination cases is, who are the parents of that child, and particularly what, if any, responsibilities does the donor of the semen have? Basically, the child is considered to be the offspring of the mother and the mother's husband, assuming the husband has consented to the procedure. And in that circumstance, where the mother is married and has a husband, the child is, of course, a child born in wedlock. The donor of the semen has no responsibility to and no relationship with the child. Indeed, in many states, anonymity is strictly enforced, and the identity of the father, the biological father, the semen donor, is never known. A somewhat newer and more ambitious reproductive technology is in vitro fertilization. In vitro fertilization, sometimes colloquially known as test tube babies. Test tube babies because the actual act of fertilization, the actual act of insemination of the ovum takes place not inside the body, but in a laboratory vial or instrument, a petri dish, or if you will, a test tube. If in vitro fertilization is accomplished with the sperm of a married man and an ovum taken from his wife, and if that fertilized embryo is then reimplanted in the wife, there are no problems in terms of ascertainment of the parents of that ultimate child. If that child survives the pregnancy, that child is the legitimate offspring of that husband and that wife. If we harvest the ovum from the wife, but use sperm from a donor and reimplant the ovum in the woman, the married woman, the wife, we will analyze the case just like artificial insemination. In other words, the donor of the semen will have no connection with the child. Rather, the husband will be considered the father for all legal purposes, and of course the woman who supplied the egg and in whose uterus the baby now resides, that woman will be considered the mother. If it is done with a donor ovum and is reimplanted in the wife of the couple, again, same analysis. Donor ovum, the woman who donates that egg, not going to be deemed a parent of the child. Rather, the woman in whose body it has been implanted will be deemed the parent of the child. Finally, you can imagine a situation in which we have a fertilized ovum implanted in a surrogate mother. We have Harry and Wanda, the husband and the wife. Maybe an egg is harvested from from Wanda, and sperm is taken from Harry, and the egg is fertilized but is implanted in a surrogate mother, Sally. In this fact pattern, the result is unclear. There is not any case law to speak of. The commentators are all over the map. It is a outer frontier boundary of the law. Many states have expressed a great deal of anxiety about surrogate motherhood in general, and consequently, we might expect at least some states to take a fairly hostile view of the entire procedure, but at the moment, the best we can do is to say that it is unsettled. Now, I said if you don't want to have children, you don't have to. If you want to have them, you can, and we've seen how science and technology may assist you. But perhaps the most important point is that if you do have them, you got to take care of them. So let us talk about responsibilities that parents owe their children. The principal responsibility that parents owe children is an obligation of economic support. Economic support is an obligation owed by both parents equally to the child, both mother and father. And it is an obligation that lasts throughout the child's minority, terminating at age 18 in most states, although there are a few that specify the age of 21. Many states will indicate, either by statute or in case law, that the support obligation continues past the age of majority if the child is mentally or physically unable to care for himself. So that you can imagine a circumstance where we have a child born with, let's say, Down syndrome, and as a consequence is really not going to be able to secure employment or indeed to function as a self-sufficient individual. Many states would say that child support under that circumstance would continue throughout the entire life of the child. Some states have said that although the obligation to pay support normally terminates at age 18, it will be extended through the period necessary for the child to secure a college education. Some states have said that. Not all, however. Other states have refused to embrace the college education obligation as part of the parent's support duty. At least one case, a case called Ross, coming from New Jersey, actually upheld a court order demanding parental contribution towards graduate school. So if those law school debts are looking a little oppressive, perhaps you want to check your home state law concerning parental support. Whatever the other rules may be about parental support, the support obligation terminates on the death of the parent. That is to say, there is no encumbrance on the estate. There is no sort of obligation to pay from the grave. How much support is owed? What is the magnitude or amount of support to be paid? Well, when the family unit is intact, and we have a married couple and we have children who are wedlock children, legitimate children of that marriage relationship, the courts generally do not get involved with an assessment of the magnitude of the support being paid. Unless the children are found by the government to be neglected or in some sense subject to significant economic deprivation, the government simply won't get involved. However, in a number of contexts where the marriage has broken apart or where perhaps there never has been a marriage, it will be up to the court to fix the amount of support to be paid, particularly for the party who is not in direct physical custody of the child. So, for instance, at the end of a paternity proceeding, there will be an order against the defendant, if he is found to be the father, to pay a certain amount of support to the mother, if the mother has custody. Similarly, at the end of divorce, how does the court arrive at the calculation of how much support to be paid? Well, in theory, the court was supposed to balance the needs of the minor and the resources of the both parents and arrive at an equitable number. But under federal law, all states are now obliged to adopt presumptive guidelines concerning the amount of support to be paid. These guidelines contain specific amounts or specific formulas based on family income and based on the number of children. They're usually in the form of a table. You can usually just look up, based on row and column, the presumptive amount of support. And many states have indicated in their case law that the trial court must offer affirmative reasons for departing from the guideline amount specified in those tables. Child support, although normally therefore based on the guidelines and therefore normally in the form of a flat economic payment, can include other obligations besides the duty to pay cash. It can include more abstract obligations, like an order that a particular parent will be responsible for medical expenses, and indeed one of the very common issues in child support orders is a command to one parent or the other to procure and pay premiums on health insurance. That will very frequently be a part of a support order. One of the most vexing problems in America today is the fact that although many support orders are calculated accurately and entered promptly against persons who plainly are responsible for particular children, those particular obligors don't make the payments. The non-payment of child support is a major problem. No doubt you have heard it bandied about in political dialogue as various politicians vie for the claim of most vigorous in coming up with methods to collect support. For present purposes, I think you need to know the following. First, the judge can direct the support order not only to the particular parent involved, but can direct that order to the employer of the parent, so as, in effect, to force a diversion of wages at the source, and thereby make it less likely that support will be diverted and that there will be non-payment. In addition, understand that the non-payment of support under a court order is contempt of court. And just as we saw in the case of alimony, we would have the full range of sanctions that any court can invoke when its orders are disobeyed. We would be able to seize property, we would be able to garnish wages, and indeed we can incarcerate the parent in question and keep them incarcerated until they pay the support. One of the problems with all of that is that while it works well enough when the obliged parent is still in the forum jurisdiction of the court that issued the order. If that obliged parent has moved away, in our federal system we may have some complexity in terms of actual pragmatic enforcement. Fortunately, there is a uniform statute called the Uniform Reciprocal Enforcement of Support Act, or URESA. There has been a revision of that. There is a slightly modified version out there called the Revised Uniform Reciprocal Enforcement of Support Act, or RURESA, and there is even newer uniform legislation in this area that has been proposed but not yet widely adopted, perhaps to be adopted in the years to come. The URESA system is really quite simple. Basically, the states have agreed, and I think every state has now adopted this scheme, the states have agreed basically in effect to cooperate with each other. What happens is that if a parent falls behind on child support and is located out of the home state of the child itself, the custodial parent will file an application in the home state. That application will in effect be mailed to the state where the deadbeat parent now resides. Having received the application, that state will use its own law enforcement processes to bring the deadbeat parent before the court, to arrest him, to bring him before the court. Once he's brought before the court, there will be a hearing as to his liability. He may attempt to show that he actually has paid the support. He may produce canceled checks. But if he cannot show that he's paid the support, the state where the deadbeat is residing will demand payment and enforce it by the direct power it has over the person of that parent. That money will be paid into the registry of the court. It will be mailed back to the home state of the child, and then will be dispersed for the benefit of supporting the child. That's how URESA is supposed to work, and when it works, it's a good system. But even in this modern day and age, it is not always possible to locate these spouses who have absconded or disappeared without making good on their responsibilities. One last point about child support, and it's a point that applies to alimony as well. Federal law is fairly clear on this. Alimony and child support obligations not dischargeable in bankruptcy. These obligations continue after you have otherwise liquidated your debts by moving through the bankruptcy system. Well, if that's the economic obligation that a parent owes a child, one of the things that is implicit in that system is that we've got a custodial parent and we've got a non-custodial parent, and that naturally forms our connection, our segue into the topic of child custody. Now, child custody, of course, is again only an issue when the nuclear family has broken up. If the married couple is still together as a nuclear couple, and if their biological offspring are living with them, custody is, in effect, non-controversial because it resides with the two parents jointly under the same roof. Assuming, however, we have a situation where the parents are no longer married to each other as a result of divorce or annulment, or because they never got married, as would be the case in a post-paternity proceeding, then we have to decide what to do about custody of minor children. The first question you need to confront is question of jurisdiction and conflict of law. Question of jurisdiction and the question of full faith and credit. Which court has jurisdiction to enter orders concerning the custody of a child? The traditional rule in the United States was a rule that led to considerable problems and indeed considerable emotional angst on the part of many families. Because the traditional rule was that a court had jurisdiction to enter valid child custody orders so long as either parent was domiciled in the state, in the forum state, or the child was physically present in that state. Now, that rule may or may not strike you as logical, but you have to combine it with a second traditional rule. A second traditional rule is that child custody orders are not considered final orders. They're not final because they're always subject to modification. Since they're not final orders, other states in the country need not afford them full faith and credit, because full faith and credit only is extended to final orders. What that meant was basically that there existed in the American scheme a virtual invitation to parental kidnapping. If after a divorce, the divorce court in, let us say, Michigan, ordered custody in the mother, the father could, let us say on a visitation day when he had the children for a Saturday, abscond with the children to Wisconsin. He could then apply to the Wisconsin court for a custody order. The Wisconsin court would have jurisdiction because the children would be physically present in Wisconsin. Moreover, the Wisconsin court had no legal obligation to give full faith and credit to the Michigan order. Consequently, Wisconsin would re-adjudicate custody, and perhaps then we would have conflicting custody orders, and we would have a situation where, in effect, the children were being shuttled about and used as pawns. Much of this problem has been eliminated by the universal adoption of a statute called the Uniform Child Custody Jurisdiction Act, the UCCJA. The UCCJA basically simply sets up a hierarchy of deference. A hierarchy of deference under which all of the states that are now parties to it, each state in effect defers to any state higher on its list that has a greater connection to the child. Basically, we are looking to have deference on the part of all states to the orders of the state that has the most significant connection with the child. So in the preceding hypothetical, if Michigan was the home state of the child, and as the home state has the most significant connection, the Wisconsin court, looking at the Wisconsin version of the UCCJA, would say, we do not have jurisdiction if there exists a state with a more significant connection. Michigan has a more significant connection because Michigan is the home state of the child, where the child has been going to school and where the child has been living. Therefore, we in Wisconsin have no jurisdiction and would say to the father, we are not going to enter a custody order. It does not solve the actual problem of the physical taking of the child, but at least it deprives the parent who kidnapped the child from bolstering the kidnapping with a court order. There is a federal statute that effectively commands the states to take this approach. It's called the Parental Kidnapping Prevention Act, the PKPA. In effect, the existence of the PKPA means that states could not repeal their version of the Uniform Child Custody Jurisdiction Act even if they wanted to, because the standards of the UCCJA are effectively mandated by the PKPA. So that's the issue of jurisdiction.